why India needs the group insolvency framework. So, in fact, the committee examined the best international practices and again decided that yes, India needs an enabling legal framework for a group insolvency under IBC. This will facilitate maximizing the value for the creditors. In case the resolution is found for the group as a whole, it will definitely find value for the creditors. It will reduce cost and also duplication. It will also improve predictability for the creditors because see, otherwise presently it is not known whether who will decide that it is a case of group insolvency, whether it can be the duty of the RP or it can be the duty of the committee of creditors who will make application. Namaste, good morning. Welcome to 153rd episode of AAA Weekly Webinar Series. Today we are discussing the part 2 of group insolvency, how it is being implemented in India, what kind of reports has already been done by the working committee. Before all that, I wish all participants, all audience, a belated happy Holi. I wish everyone should emerge as beautiful colors in their life. The Holi celebrations must have been very good for everyone. So continuing with our webinar, and this is 153rd weekly episode. We do not have Ankit today because of some contingency, and we are going to discuss part 2 of group insolvency. In fact, the work which has been done so far, there was a working group constituted by Ministry of Corporate Affairs and IBBI, and that report was delivered on 23rd of September 2019. Then there was a committee on cross-border insolvency rules and regulation committee, and then the part 2 of that committee was also for group insolvency, and that report was given in December 21. However, after considering everything, I believe the government have decided now to implement the group insolvency in a different manner, which is now part of the discussion paper dated 4th of February 25. And to my understanding, the government have decided to implement the complete part of group insolvency. And the second part, the first part, the government is implementing now by way of making amendment in the regulations, in case these regulation, whatever is proposed in the discussion paper, are notified. And the part 2 will come after the amendment for cross-border insolvency is done or the cross-border insolvency is implemented. Thereafter, part 2 of group insolvency would also be implemented by the government of India. That's what is my understanding from this working group recommendations and also CBIRC part 2 report. And finally, looking into all the discussions by the working group and CBIRC and whatever is implementable before we implement cross-border insolvency has already been proposed in the discussion paper. So once this discussion paper is notified as regulations, I believe the group insolvency will be considered as implemented in phases. And the first phase would be fully implemented because the discussion paper is very, very elaborate and all the recommendations which is supposed to be accepted by the government, that is being done in this discussion paper. Now, going forward, as we are saying that this structure of the report, because see the working group report, in fact, the first of all, in fact, in the episode, which is part 1, episode 152 of AAA Weekly Webinar Series, and part 1 of group insolvency, we deliberated on what exactly were the issues which was discussed by working group, delivered their report in 2021. And in fact, we are very briefly, we are discussing that after that working group report, the assignment of drafting of regulations and rules were given to Cross-Border Insolvency Rules and Regulations Committee, Part 2. And that was constituted, and it was mandated to them that they would be drafting rules and regulations for based on UNCITRAL model law on enterprise group insolvency. So model law on enterprise group insolvency, in short, we can also say 𝐄𝐦𝐚𝐢𝐥. So based on 𝐄𝐿𝐴𝐺, the mandate was given to CBIRC Part 2 to draft rules and regulation. So then in fact, the first part of the CBIRC Part 1 was for cross-border insolvency rules and regulations, and Part 2 was supposed to deal with enterprise group insolvency and the challenges posted by interconnected group enterprises and entities in the insolvency situations. So let us also briefly discuss, like, why was this report needed? And when we say why was this report needed, we can also say that the report was needed because the business was increasingly operating as enterprise groups, meaning multiple legal entities are controlled by common holding entity or management. Insolvency law currently treats each and every entity separately, and insolvency is also kind of started and continued separately for each entity, and there is no coordination possibilities other than couple of the jurisprudence which we have seen in Videocon and 2 more cases. But the other issues which are like internationally, this UNCITRAL legislative guide on enterprise groups that was made in 2010, and 𝐄𝐿𝐴𝐺 was made in 2019. So in fact, based on these 2 documents, based on these 2 work done by UNCITRAL, then the report was needed to understand whether that particular 𝐄𝐿𝐴𝐺 and the guidelines, which is the UNCITRAL legislative guide on enterprise groups, whether that can be implemented in India as it is or some amendment is required. Now, in fact, the CBIRC Part 2, based on the report of working group, they also started almost afresh, because see, that was done in 2019, and this particular regulations making process or rules making process was a little elaborate. So they in fact discussed with various stakeholders, legal experts, insolvency professionals, and also like international scholars. They also kind of seen comparative legal research, studied global practices from Germany, UK, US, the European Union regulations, and also UNCITRAL guidelines and 𝐿𝐴𝐺. They also kind of reviewed Indian jurisprudence that they have seen in Videocon and 2 more cases. Then in that scenario, they also did some policy recommendations in Indian framework, depending upon what is the present status of implementation of cross-border insolvency, what is the present capacity of NCLT, what is the present knowledge level or experience of present stakeholders. So considering all this, there were some policy recommendations. And the committee also, in fact, summarized key challenges in the group insolvency. One is the economic reality versus the legal treatment. Now, the economic reality is that there are many decisions which are taken as a group. The entire group is controlled by a few people, few stakeholders, and a very centralized management. But legally, each and every entity of the group is treated separately, and therefore it can cause inefficiencies. Then the committee also identified that there are interconnected assets and liabilities. For example, there are assets which are shared between the group. There are cross guarantees and the cross collateralization of secured assets. Related party transactions are too many, and also therefore the making a standalone resolution for a company which is depending on the other companies would be inefficient and difficult. Secondly, when the multiple group entities spans to multiple jurisdictions, overseas, various other countries, then the courts are struggling to coordinate between the various courts, and the international and domestic proceedings are presently not regulated because of the non-implementation of cross-border insolvency. The legislative guidance is also not available in India, except a couple of cases. So insolvency law as of today does not deal with group insolvencies. So courts have started taking some decisions based on these are ad hoc solutions, and there is no standardized rules or standardized regulations. And also, why this committee said that why India needs the group insolvency framework. So, in fact, the committee examined the best international practices and again decided that yes, India needs an enabling legal framework for a group insolvency under IBC. This will facilitate maximizing the value for the creditors. In case the resolution is found for the group as a whole, it will definitely find value for the creditors. It will reduce cost and also duplication. It will also improve predictability the creditors, because see, otherwise presently it is not known whether who will decide that it is a case of group insolvency, whether it can be the duty of the RP or it can be the duty of the committee of creditors who will make application. So that is the kind of unpredictable situation. So in case any such group insolvency law is made, then it will become predictable that this is a case which is fit for group insolvency. Otherwise, the creditors are just kind of apprehend, like they only apprehend whether it will be a group insolvency or it will be a entity-wise insolvency. So like then when this committee kind of again analyzed in detail 𝐄𝐦𝐚𝐢𝐥, that is the model law on enterprise group insolvency, which was released in 2019 by UNCITRAL, the committee proposed that it should be voluntary and flexible approach, and it should not be mandatory or it should not be fixed one. And then they also recommended that the joint applications can be made. I think joint applications are not proposed in the discussion paper, but joint hearings are proposed. Then the committee recommended the common insolvency professional, that is accepted, that is proposed by the discussion paper. Then cooperation amongst court, it is definitely implemented because of within the discussion paper, because it is common hearing, joint hearing is proposed in the discussion paper. And the group coordination proceedings, that is not something which is presently required. This is what is felt by the IBBI. So when they made this discussion paper, so in fact they are proposing now that the joint hearings would be done, common RP would be done, and synchronized timelines also would be there for all the entities. Information sharing between all the that is also being done, and any other matter. Now, any other matter that can also include joint COC, combined COC, that can also mean group coordination coordinator. So that can also mean many other things, because that is left to the commercial wisdom of committee of creditors in the proposed discussion paper. So what I'm trying to say, in the proposed discussion paper, whatever has been discussed by working group, whatever has been discussed by CBIRC Part 2, that is almost implemented. And the next phase will only come after the cross-border insolvency is implemented in India. Now, CBIRC Report 2 part, in fact, assessed whether what kind of, which part of the 𝐄𝐦𝐚𝐢𝐥 should be adopted by India. So in India, the committee recommended that the India should first implement a domestic group insolvency framework before adopting international rules. That is what is type of being done by the IBBI through the discussion paper, which is 4th of February 25, and it will be notified, hopefully without any changes. Also, 𝐄𝐦𝐚𝐢𝐥 adoption should be considered only after single entity cross-border insolvency laws are enacted. So presently, we do not have even single entity cross-border insolvency law. First of all, we should have the single entity cross-border insolvency law. Then only we can have a group insolvency. Because see, when we talk about the group may have various entities, as we have seen in the last many cases, that the various entities which actually have gone into insolvency, they were having many subsidiary companies or holding companies overseas. Since the cross-border insolvency is not implemented in India, therefore, even the group insolvency would also be useless. So that's what is the recommendation. And then the committee also recommended, based on the recommendations of working group, one, the exclusion of solvent entities. It is recommended, even by the working group, it is recommended that only distressed corporate debtors should be part of the framework. And secondly, financial service providers like banks and NBFCs shall be excluded. In any case, the financial service providers are presently, it is at the instance of RBI that can go into insolvency, but the only distressed corporate debtors should be part of the framework. In fact, there is a possibility that even some of the solvent entities can also be part of the group insolvency, and that can be voluntarily. In India, if a company which is solvent and has not defaulted, and that company feels that it is good that in case that company will become part of this group insolvency, otherwise that company will be left standalone, and that company will neither have the customer nor have the supplier, and because that is a kind of sandwiched company between the customer and the supplier. And if the customer is also not left, and if the customer of that company is also in the group, and the supplier of that company is also in that group, so where this company will function? So that company can voluntarily say that there is a default, and that can join that particular group only to save value for that company. That is actually practically possible. And also in this proposed regulation, which is regulation 40 capital E, the IBBI have also proposed a kind of residual clause, which is other measures as may be required. Now, the few measures have been identified very clearly: joint hearings, common RP, synchronized timelines, information sharing, and other measures as may be required. So other measures as may be required, that means it is an enabling clause. So once we have enabling clause, that means that the COC can decide, or the COC of different companies can decide whether they would like to be part of the group or not. Now, the second discussion, which is very important, it was a discussion in the working group. It is a discussion in the CBIRC committee. And also, in case we see, the 𝐄𝐦𝐚𝐢𝐥 also have discussed it at large. So what is this discussion? One is the kind of substantive consolidation, and the second is procedural consolidation. Now, when we talk about substantive consolidation, that actually means that in group insolvency, even the assets and liabilities also would be consolidated into one resolution plan. However, the working group and the committee CBIRC has recommended that it would be only a procedural coordination and not asset liability pooling. Also, the court should decide consolidation on case-to-case basis. Even internationally, this substantive consolidation is not really applied very frequently. It is in a very, very rare cases that it is applied. Now, we will discuss about the substantive consolidation and procedural coordination. So these are the two concepts, like these are the two levels of the group insolvency. You can say one is a very, very high level of group insolvency, and the other is only a procedural level of group insolvency. So we will discuss in the following slides. Now, when this model law, which was developed in 2019 by UNCITRAL, which is called 𝐄𝐦𝐚𝐢𝐥, that is actually a global approach to group insolvency. But see that 𝐄𝐚𝐢𝐥 is providing a global approach, whereas the global approach presently is not required in India. And the 𝐄𝐚𝐢𝐥, in fact, was focusing on the cooperation amongst courts and insolvency professionals across borders. And it was offering the flexible guidelines that the nations can adopt to their domestic laws. But when we actually see, the key features of 𝐄𝐚𝐢𝐥 was to encourage voluntary cooperation between the courts and insolvency professionals across jurisdictions. And then the enterprise group definition was also including the including the domestic and a global kind of control and management. Now, and when I see the group coordination proceedings for common strategy is also kind of key features of 𝐄𝐚𝐢𝐥. Appointment of a group coordinator. Even the 𝐄𝐚𝐢𝐥 has recommended that there can be a group coordinator which can be appointed. And in that specifically when there are cross-border insolvencies are involved. And the group coordinator has a role, which we will discuss what kind of role was in fact defined by 𝐄𝐲 in their report, in their work. Then no substantive consolidation. It was not. It was also recommended that the substantive consolidation should only be voluntary. It should not be mandatory. Although the 𝐄𝐲 recognizes the legal entities of the group separately, and the consolidation, which is substantive consolidation, should be only in the rare cases where the assets and liabilities are highly intermingled. There are other reasons also highly intermingled, or even when there are perverse transactions or perverse behavior of the promoters. There are some fraudulent transactions with some of the group entities. So in those cases, it is recommended that the substantive consolidation should be done. All the assets and liabilities of all the group companies should be pooled together, and a common resolution plan. So each stakeholder would lose their individual claim in the individual entities. So therefore, in fact, this part of the 𝐄𝐲 that we discussed, it is not being recommended for India. One, that it is too complex for any immediate adoption. Number two, India presently lacks cross-border insolvency for even single entities. So the committee says, first, cross-border insolvency for single entities must be implemented. And in case we adopt 𝐄𝐲, it will be premature and could lead to legal uncertainty. So the committee also recommended that we should acknowledge the economic realities of India. Group insolvency should recognize interconnected financial structures. Framework should increase recovery value. It should reduce the cost. It should reduce some judicial burden. And it should have sometimes some kind of legislative certainty and creditors' confidence on this structure. So that is what is recommended by 𝐄𝐲. Now, the final recommendations by the committee is like a group insolvency, domestic group insolvency framework should be created first. Then 𝐄𝐲 adoption should be considered later after evaluating the implementation of single entity cross-border insolvency laws. Third, procedural coordination should be in focus rather than substantive consolidation. Fourth, the framework should be voluntary, flexible, and phased in implementation. Accordingly, the committee noted that there are various benefits to designing a legislative framework for a group insolvency that may be inserted in the code. It discussed that such a framework should be enabling, flexible, and voluntary in nature so as to suit different ways in which group may be interlinked. Thus, the committee has prepared a list of recommendations for designing a group insolvency framework as detailed in the coming part. And a draft group insolvency framework designed based on these recommendations, which may be inserted in the code, and this may be referred as draft part ZA. You would recall that for cross-border insolvency, the same committee has recommended part Z of IBC. And now, in fact, they recommended part ZA for the IBC to be added to IBC with a parliament action. So, consequent amendment in the existing provisions of the code may be required of this part as inserted in the code. But when I say that it is being done, part ZA was drafted, even part Z was also drafted. So finally, the committee also says first part Z should be implemented, then only part ZA will come. So therefore, presently, there is no recommendation that the part ZA will come immediately. There is no such recommendation. So also why immediately we are not implementing the group insolvency, because the group insolvency, in case we implement and we do not implement cross-border group insolvency, then it actually will become difficult. So in case we have to adopt, first of all, cross-border single entity insolvency, then only we can implement cross-border group insolvency. So first, we would be implementing the part Z to the IBC, and then we may even come later to part ZA. However, this discussion paper has already implemented part of part ZA, which is group insolvency in India. However, the cross-border group insolvency will take some time because there are some challenges that it cannot be done presently in the present circumstances, because there are like different unharmonized insolvency laws in different jurisdictions in the world, and then it will be difficult to understand which part of the law would be applicable to which company, which entity, in case it is a group insolvency, because the cross-border insolvency is not yet recommended. Jurisdictional issues, of course, as we understand which jurisdiction would be the main commie and which jurisdiction will be main proceedings and the sub-main proceedings. Then recognition of the foreign orders are not presently implemented, stakeholders protection, all this is not yet done. So therefore, the two broad coordination strategies for handling insolvency in group companies was the substantive consolidation is not recommended, and the assets and liabilities of the group companies are pulled together, that is not implemented. Treated as a single insolvency estate for recognition, reorganization or liquidation or resolution, that is also not implemented. Creditors of individual companies lose their separate claims, that is also not implemented. Common internationally, but applied selectively based on. So this substantive consolidation is common, but it is selectively applied. It is only applied where the intermingled finances are there, common management there, and the operational integrations are there. And also the group also, in fact, the substantive consolidation in a group insolvency, it is seen because see, there are like limited liability concepts of the entities. The legally company law says that the limited liability would be there. And also the substantive consolidation is seen as a very kind of a radical remedy, and some jurisdiction may or some jurisdiction may not permit that. And also in kind of related party transactions, the factors for determining the liability in a corporate group, interconnection of management and the administration and finances, conduct of related companies towards the creditors, perception of creditors, whether they viewed multiple companies as one unit or not. So these are various issues which actually are basically saying yes or no for substantive consolidation. And then we also see, in case no substantive consolidation, it is only a procedural coordination. In the case of procedural coordination, which is almost going to be implemented in India by way of notification of proposed discussion paper, which is aiming at improving efficiency, avoiding conflicts, and also ensuring better realization of assets. Then insolvency proceedings of group companies are synchronized instead of merging assets and liabilities. The hearings will be common, the timelines will be common, and each company's insolvency would be administered separately. Each company COC would be separate. Anything which is approved will have to be approved from each company's COC, and the coordinated timelines, procedure, all this is basically in the procedural coordination. So we are going to implement the procedural coordination in group insolvency, but we are not implementing substantive consolidation, where the assets and liabilities are also pooled together, resolution plans or liquidation are pooled together. That is not being implemented, and neither we are implementing cross-border group insolvency. So this is where we are. In fact, when we talk about the substantive consolidation, as I said in the beginning, that we will discuss in length. So even the UNCITRAL legislative guide Part 3 recommendations on substantive consolidation limited the use of two exceptional scenarios. So this guidelines, which were released by UNCITRAL in 2010, in fact gives two exceptional scenarios, and in these two exceptional scenarios, only substantive consolidation should be implemented. And the first scenario is if a court is satisfied that the assets or liabilities of the group members are intermingled in such a manner that it is difficult to identify the ownership of assets and liabilities without disproportionate expenses or delay. Second scenario, if the court is satisfied that the entities of the same group are engaged in fraudulent activities, and if the substantive consolidation is essential to rectify such activity. So these are the two scenarios where this UNCITRAL Legislative Guide Part 3 recommendations carries that it should be used in these two exceptional circumstances and scenarios. So now we actually can see, let us kind of see the as far as this position in 𝐄𝐦𝐚𝐢𝐥 is concerned. 𝐄𝐦𝐚𝐢𝐥 is in fact silent on the issue of substantive consolidation. In India, we are not even thinking of substantive consolidation. But in some cases, in future, it will become very important, because in case we keep some of the entities of a group away from insolvency, then there is a possibility that the valuable assets, active assets, can be somehow shifted to the solvent company, which is not in insolvency. And that would, in fact, cause loss to the stakeholders. And also, wherever there are related party transactions, transactions between the group entities are made in such a manner that the entire profit is going to the solvent company and all losses are coming to insolvent companies under insolvency. So to avoid such scenario, it may be a possibility in future that even those companies are also brought to the net of group insolvency, where the substantive consolidation also would be recommended. Now, let us see what happened in the judicial pronouncement when this Videocon Industries Limited case, it was decided by NCLAT that it can be a group insolvency in the case of State Bank of India versus Videocon Industries Limited. In fact, it was insolvency of 13 out of the 15 companies belonging to the same group were ordered to be consolidated based on the following set of factors. In fact, that was kind of substantive consolidation, very, very rare, where all the companies had common control, common directors. Common control means common management control, common directors, common assets, common liabilities, interdependence of the companies. Interdependence of the company means that the one company is manufacturing one component and supplying to the main company. The other company is also manufacturing other component and supplying to the main company. Then interlacing of finance, then pooling of resources, then coexistence for survival. Coexistence for survival is very important. Why I'm saying so? Because there can be a company which will actually left with no customer and no supplier, and they only have an infrastructure. Because that company was only depending upon the group entities. So therefore, the coexistence for the survival, intricate links between the companies, intertwined accounts, interlooping of debts, singleness of economic of units, common financial creditors. So these were all the issues which actually were seen in Videocon, and therefore it was substantive consolidation. It was not procedural coordination. It was substantive consolidation. And in the Axis Bank versus Lavasa Corporation, NCLT Mumbai consolidated insolvency proceedings of group companies, citing dependency on the parent company's resolution. Because see, the holding company was in fact depending upon the parent company. So therefore, NCLT Mumbai consolidated the proceedings. And another company, which is Edelweiss Asset Reconstruction Company versus Sachet Infrastructure Private Limited, where the NCLAT consolidated insolvency of 5 companies in a township project to protect home buyers' interest. So therefore, all these three things that we have seen, where these judicial pronouncements are seen, after this discussion paper is implemented and notified as regulations, I think all this will become standard, and the committee of creditors, the resolution professionals, they would be able to take a decision as per proposed regulation 40 capital E, and they would be able to see whether the value can be enhanced, or time can be saved, or cost can be saved, or a better resolution can be found. The committee's observation on substantive consolidation is the court, it all depends on the courts. As I said, even in my explanation, that in case the court see that there are activities which are perverse activities from the group, from the management, to avoid those perverse activities, the role of the adjudicating authorities, and the adjudicating authority can even order for substantive consolidation. The courts can respond to the economic realities of case-to-case basis, and the only focus should be maximization value for the stakeholders, and considering economic factors and the legal factors and practicability, the courts can take a decision about substantive consolidation. However, the discussion paper is only recommending the procedural coordination. So even this was also discussed that since the judiciary has already started doing this group insolvency, however, why these statutory provisions are required, now when we see this discussion paper, it is definitely required, because the committee of creditors and the resolution professional will consider this as their duty to make an application, and therefore not only depending upon the judicial precedents, so there would be a regulation to base upon their action. So therefore, we actually can see that the case-specific substantive consolidations are also possible, and this is where we have discussed, but that is only in case it is required, and it is mentioned in the regulation 40E, which is proposed as other measures as may be required. So it will be based upon the commercial wisdom of committee of creditors, factors, as we have seen in the video con. There are factors which actually forces the committee to think about substantive consolidation, which means pooling of assets and liabilities, and which also means pooling of the resolution plan and everything which actually comes together. And the individual claims are, in fact, of each stakeholders would lose. However, it is nowhere said that the resolution plan will be up. There is nowhere where the proposal that there will be a common COC. The COC will be individual COC, and if there is a resolution plan, that will be approved from all the COCs, and then it can be considered as approved. So the committee also recommended that as far as this any rules and regulations for substantive consolidation, if required, that will be made in future and not now. So when we talk about procedural coordination mechanism, which is discussed by the committee, CBIRC Part 2 committee. So this is, these are the kind of actions which actually would assure procedural coordination. Joint application, this is presently not proposed. What is proposed in the discussion paper, that if two or more companies are under insolvency, then such application can be made. Single insolvency professional, yes, it is proposed. Group committee of creditors, it is not proposed. Each and every committee would be separate, and anything which is approved, which will have to get approval from all the committees. Group coordination proceedings is not recommended for the time being, but synchronized timeline is recommended and also proposed, and joint hearing is proposed, common RP is proposed, sharing of information is proposed. That is what is proposed. But then the three things are not proposed. One, joint application and group COC, and the group coordination proceedings, maybe group coordinator. So that is something which is not proposed. And in fact, the working group recommended a non-prospective adoptable framework for procedural coordination under IBC. Like I said, that the key elements of this recommendations or joint application for initiating group insolvency, communication, cooperation, and information sharing among stakeholders, appointment of a single insolvency professional and a single adjudicating authority, creation of a group creditors committee to oversee collective interest, group coordination proceedings to streamline case management, shifting of the cases of all the companies to one adjudicating authority, which will be the first one that is proposed. But application to a single adjudicating authority is not proposed. Secondly, it is very important that this most elements which is recommended remains voluntary, and the only thing which is mandatory is the cooperation, communication, and information sharing, insolvency professionals, amongst insolvency professionals, committee of creditors, and the adjudicating authority. That is the only thing which is mandatory. Otherwise, everything is advisory and recommendatory. And the committee finally says that the committee agreed with the working group approach and emphasizing that there is a need for the framework, a flexible framework rather than rigid statutory provisions, allowing stakeholders to negotiate the best method of procedural coordination based on the commercial feasibility, ensuring efficiency while preserving party autonomy in insolvency proceedings. Procedural coordination should remain adaptable rather than being overly prospective. Mandatory elements should be limited to communication and cooperation. Parties should have the freedom to adopt mechanisms that align with economic and commercial realities of their group insolvency cases. And the mandatory procedures coordination mechanism, mandatory procedure is like single forum, like single NCLT or adjudicating authority, and the communication, cooperation, and information sharing, that is the only thing which is mandatory. Other things are all voluntary. Now, in this table, we have now given the various recommended procedural coordination mechanism. What we have already decided that the substantive consolidation is not being done. That would be possible only on case-to-case basis, and that would be possible as per the UNCITRAL legislative guide only in two scenarios that we have already seen. We have already seen that the Mulegi doesn't have anything regarding the substantive consolidation of assets and liabilities and the resolution plans or reorganization plans or liquidation. And finally, the procedural coordination mechanism is the only thing which is left, which is to be implemented in this phase. So this table shows like what is this single insolvency application for multiple corporate debtors in a group. So this is permissibility. Each group member must satisfy the commencement standards under section 7, 9, 10. In case we have to file single insolvency application, the committee recommended that each group member must satisfy the commencement standards under section 7, 9, and 10. Although this is not presently being implemented, but in case in future it has to be implemented, they would actually say that each and every entity of the group should have all the commencement standards under section 7, 9, and 10. Jurisdiction, a joint application may be filed to NCLT. And then like procedural is the common form should accompany these applications. That is also, it was recommended. Joint applications will improve efficiency and reduce cost by allowing the common date of commencement. Joint application will help common date of commencement. And then solvent group members may voluntarily participate in the resolution by submitting resolution plans or providing interim finance. That is also a voluntary part. Then international practices are in USA, the joint filing for all group members are common. In the UK, simultaneous application for different group entities are filed before the same court. Each group member retain the right to withdraw under section 12A, appoint independent resolution professionals. Then a joint application may be filed in any NCLT that has jurisdiction over at least one group member. All CIRP and liquidation proceedings of the group members should be filed, transferred to the NCLT single forum for conduct. The NCLT should administrate all proceedings. So in case we see the international practices in USA and Germany, insolvency cases of group companies are typically handled in a single forum. Courts and insolvency professionals should communicate and share information to coordinate cases effectively. Related proceedings, avoidance transactions, and etc. should also be filed in the same NCLT. A common RP or liquidator may be appointed for multiple group members undergoing CIRP liquidation. COC of each group entity should decide whether to appoint a common RP or not. NCLT may appoint a common liquidator if it enhances value maximization for creditors. The code should not mandate the appointment of a common insolvency professional for all group debtors. CIRP regulation should be amended to allow appointment of common RP even if they do not qualify as an independent director for all group entities. Common RP liquidator must avoid conflicts of interest, especially in cases involving intra-group claims, avoidance actions, and interim finance. RP liquidator should disclose potential conflicts of interest at the time of appointment and during proceedings if conflict arise. If conflict of interest arise after appointment of RP, should approach NCLT for directions, including the appointment of a special RP to handle intra-group disputes. COC of different group members may decide to form a group COC for a better coordination. The formation of a group COC should not be mandatory, should be based on the decisions of individual COC. The group COC only provides procedural assistance and does not have the power to make substantive decisions. No specific amendment to the code is required to allow a formation of group COC. The existing cooperation and coordination provisions are sufficient. The substantive rights of creditors remains with the COC of each corporate debtor. The group COC cannot override individual COCs. In USA, the Group Creditors Committee helps in negotiations, but voting remains with individual COCs. In Germany, a Group Creditors Committee assists individual COCs and insolvency professionals in coordination. If a group coordinating proceedings is initiated, the formation and powers of the group COC may be different. COC and insolvency professionals handling insolvency proceedings of group members must cooperate, coordinate, and share information. Cooperation should include information sharing with confidentiality safeguard, allocation of responsibilities, and coordination of administration. Court should cooperate to the maximum extent possible with other courts, insolvency representatives, and group representatives, if any. Insolvency professionals should work together through information sharing, coordination agreements, and resource allocation. The extent of cooperation should be left to the discretion of insolvency participations based on the circumstances of each case. COC and insolvency professional may enter into inter se agreements to define the extent and nature of cooperation. Since all CIRP and liquidation proceedings of a group must be transferred to the same NCLT, no separate provisions for inter-NCLT corporations are needed. COC can also initiate group coordination proceedings. COC of participating group members approve a framework agreement with the requisite threshold. Framework agreement covers estimated costs, cost distribution, appointment of a group coordinator, and a mechanism to opt out. All adjudicating authorities are notified and cases are transferred to a single adjudicating authority. Cases transferred to a single adjudicating authority chosen under the framework agreement. Group coordination proceedings in CIRP do not automatically continue into liquidation. So this is all which is the committee recommended that I have said, I have read from my PPT. Now, all this will happen sooner or later. The group COC, it can also happen because see, once a concept is introduced and it is recommended by a committee, rather two, one is a working group and the other is a committee of the cross CBIRC. Then there is a concept, there is a reasoning for it. And the judicial authorities would actually help uh, adopting any of these concepts in case it is required, as the regulations are very well clear about all other measures as may be required. So in any case, in case the group COC would be required, already there is a concept introduced. In case there is a group coordination committee or group coordinator is required, already there is a concept which is already introduced in the this. So all this is very important to understand that it is all being done. So I will not discuss much on the group coordinator and the manner or their appointment because of the time issues and powers of the group coordinator, that we will in fact discuss some other day when it will be introduced. So presently it is not being introduced, and so therefore group COC is also not being discussing what would be the kind of so we, in fact, now would be discussing what exactly was the discussion paper, what is the proposed regulation 40 capital E, which will be notified maybe sooner in case it is not amended. So the IBBI, in fact, while releasing this discussion paper, in fact, discussed that presently it is only a standalone approach under IBC, and each entity is treated independently, leading to inefficiencies. Judicial recognition, but no statutory framework. They said that it has already been recognized in Videocon, it is RAI infrastructure, but there is no legal formal provision to streamline interconnected CIRPs. The cost is increasing, duplicative proceedings are happening, lack of synergy utilization, leading to suboptimal creditors recoveries, and then uncoordinated decision making and delays and conflicts are happening. So therefore, there should be a formal mechanism, and which they are now proposing to enable coordination of the CIRPs and the control interconnected by the control or significant ownership. In fact, they have also defined what exactly is the interconnected control. Now, we need to read now what is the proposed regulation 40E, which is introduced through the discussion paper on 4th of February 2025. The first thing which is to be seen is the where two or more corporate debtors undergoing CIRP. So one, that it is only applicable if two or more corporate debtors are undergoing CIRPs and they are interconnected. They are interconnected, which may be based on the existence of control or significant ownership. So there are two concepts that they have introduced: control and significant ownership, and they have defined that also. We will come to this later. So the control and significant ownership, then the one, we have to see that the two or more corporate debtors are under CIRP. Then they have there is an existence of common control and significant ownership, interconnected. Then the RP or any of RP of any such CD may, it is not mandatory, may file an application with the adjudicating authority for coordinated conduct of the processes, subject to obtaining prior approval of each committee of creditors. So in case two companies or three companies are under CIRP, so each committee will first of all approve a coordinated conduct of the process. Again, with vote of 66%, then only the application can be made by the resolution professional to adjudicating authority. So application, now it is very clear that the application will be filed by the RP only after taking approvals from the various committees, different committees. Now, for the purpose of this control, the regulations say that it will be as defined in the Companies Act. We will come to the definition also as per the Companies Act. And in case of limited liability partnerships, it shall mean the ability by virtue of voting rights, partnership interest, or contractual arrangement to direct the management or policies of the limited liability partnerships, or to appoint or remove the majority of its designated partners. And the term significant ownership shall be defined as the ability to exercise 26% or more voting power. We will come to this control and significant ownership. Once this application is made and the adjudicating is adjudicating authority is satisfied that two and more companies are under CIRP. Number two, they are interconnected. Number three, they have a common control. Number four, they have significant common ownership. Then the adjudicating authority may, if satisfied that the coordination would be in the interest of the corporate debtors and their stakeholders, then they can pass an order. What kind of order the adjudicating will pass for? One, joint hearings, that from now onwards, all the hearings will be joint. Appointment of a common resolution professional, information sharing between the resolution professionals, coordination of timelines, or any other measure as deemed fit. Any other measure as deemed fit that we've been discussing for the last 40 minutes, that any other measure may include many other things. So that actually will implement even a substantial part of group insolvency in India. So then, when we see this control under the Companies Act, and now we can see Section 2, subsection 27 of the Companies Act 2013 defines control shall include the right to appoint majority of the directors, or to control the management, or policy decisions exercisable by a person or persons acting individually or in concert, directly or indirectly, including by virtue of their shareholding or management rights or shareholder agreements or voting agreements in any other manner. So that is what is the definition of control under the Companies Act. Very wide. It includes directly or indirectly. It includes acting individually or in concert. So therefore, including by virtue of the shareholding or management rights or shareholders agreement, then significant ownership is defined as 26%. And so then the adjudicating authority, in fact, will pass that kind of order. So this is what is the implementation of group insolvency in India in phased manner. Once this discussion paper is notified without amendment, this is what is going to be implemented. Then we are not going to see anything which is in near future regarding the group insolvency other than judicial pronouncements, or the judicial pronouncements will also be out of the concepts that we have discussed in part 1 and part 2 of group insolvency episodes. So this is we complete our group insolvency, and in the next episode we are also targeting to give our audience a comparative analysis of insolvency law in overseas jurisdictions. We will cover at least 6 countries and what kind of differences are there in the insolvency law in other jurisdictions and in India. So we have completed 3 parts of cross-border insolvency, which is very important to be implemented. And part Z has already been drafted by CBIRC part 1, but that needs induction in the insolvency code that will be done through Parliament. Group insolvency, whatever the phase 1 has to be, that has been done. And just the comparison in the other jurisdiction insolvency law is just for understanding how the other countries are having their insolvency laws. So this is what about 153rd episode of AAA Weekly Webinar Series. Thank you very much. This is our way of learning.